Please do continue enjoying your lunch, but I should tell you to beware because I will probably have some questions for you as I go through the presentation, and I hope you have we'll leave some time at the end for you to ask some questions of me. So I am Ellen Rosen. I am the Regulation and Global Initiatives Counsel at the ABA Center for Professional Responsibility. It's a little bit different than ABA ROLI. We're all part of the same ABA family. But the work that I do is part of what I like to talk about as a little think tank that focuses on ethics and professional responsibility within the ABA. And I've been practicing in the area of ethics and regulation for 33 plus years. A lot of my work is consulting with lawyer regulatory systems about their ethics rules and their discipline systems. I do that in the US and I do it abroad, so I understand the tremendous work that your Bar Council has undertaken and the incredible amount of work, positive work that they've accomplished in a very short period of time. As you heard the speakers this morning say, this is really a journey. And so things are going to continue to happen. You've got the bar exam coming up. You've got your ethics rules and your discipline system in place, and they're operating, but you have a very new system. And so what I want to give you this afternoon, before we get into the panel discussion, where we're going to dive a little bit deeper into some things like efficiency, is kind of a sense of where you align with international best practices. Of course, taking into account local factors, because every system has to do that, whether it's the size or other types of cultural factors. So what you're going to hear me say a few times is that there is no one-size-fits-all right answer. So because your system is new, there are likely going to need to be adjustments over time. That is common. I understand you have already had some amendments to the Legal Profession Act. And this is, again, as I said, it's not uncommon. Systems need to evolve with jurisdictional changes to see what works well, what can use improvement, and there's always going to be changes in legal practice and regulation. So, generally speaking, and this applies globally, these are the general purposes of lawyer discipline, and those are consistent with the objectives that are set forth in the Maldives Rules of Professional Conduct for Lawyers. Optimally, your lawyer discipline system, the enforcement piece of your professional conduct rules, are going to have these components. And again, these are common globally. With regard to the sanction standards, the standards for imposing lawyer sanctions, I'm going to hold off a little bit on that because we're going to touch on it more in the following panel. But generally speaking, what that refers to is a framework for helping to ensure that you have consistency in sanctions in like cases, because you have ethics panels that are making these recommendations to your exco. And so you need to make sure that if you have a lawyer who's being considered by one ethics panel who is engaged in a conflict of interest, and you have another lawyer before another ethics panel who's engaged in a similar conflict of interest, when those recommendations are being made to your exco, that they're consistent. The other thing is that historically, discipline systems have evolved over time. So you see something called preventive programming. It used to be, in the United States, for example, our discipline system was purely prosecutorial. It was geared just towards discipline, and that has evolved over time. It's not only evolved in the US, it's evolved globally, so that the system itself focuses on disciplining those where it is appropriate, but also finding ways to help lawyers who may not have engaged in bad misconduct. They may need some help with law office practice management. They may need some help finding better ways to communicate with their clients. They may need some educational assistance, so things that are remediable, and they're a way to pull these out of the discipline system and have the bar help these lawyers. It's good for lawyers, it's good for the clients, and it allows the regulatory system to focus its resources on those cases where you have a lawyer really engaging in some bad conduct. So that would be the preventive programming piece of it. So in the context of giving you this sense of where you might fit within kind of the global picture, I looked at a number of different models. We have our ABA model rules for lawyer disciplinary enforcement. That is the model that the ABA develops that we put forth so various jurisdictions can adopt that. Our state Supreme Courts, you heard Judy Gunderson say, our state Supreme Courts are responsible for regulating the profession in the U.S. So we create these models and we ask the courts to adopt them, and we're very successful in that. I also took a look at the International Bar Association Guide for Establishing and Maintaining Complaints and Disciplinary Procedures, which I worked on as a member of the IBA, the Singapore Legal Profession Act. Federation of Law Societies of Canada also develops national standards, national models like the ABA, and the Solicitors Regulation Authority discipline procedures for the Law Society, for England and Wales. So based upon that review of these international models, generally these are the characteristics that, in my view, a discipline system would optimally have. How the system accomplishes these goals is going to be dependent on a number of factors that's unique to each jurisdiction. As I said earlier, there's kind of no one-size-fits-all approach. No system is going to be perfect. For example, no system that I'm aware of is able to meet their goals of timely investigation and prosecution all the time, because there's so many factors that come into play in the efficient handling of cases, and we'll talk about that again during the next session. So appropriate resources, absolutely critical to an effective, efficient, fair, and accountable system, regardless of location. An evaluation of system resources is something that has to be ongoing and that I often recommend when I do consultations, as we urge the, excuse me, either the disciplinary agency or the Bar Association to constantly be reassessing resources to determine if the system has enough. So we call this doing a true needs assessment. Now, the source of the funds is going to vary jurisdictionally. In the United States, for example, no taxpayer dollars go towards funding lawyer regulation. It's all done through our licensing fees. That's similar in other jurisdictions. In some countries, the legislature may provide funding, or a portion of Bar Association dues are used. So another way to help fund the system, if you will, to make sure it's got stable funding, is once you are done prosecuting a lawyer, and if discipline is imposed, many jurisdictions will actually seek to recoup the costs of the investigation and prosecution from that lawyer. It's separate from a sanction. For example, I know you have fines here in the Maldives under your rules. That's separate from fines. It's really just a recoupment of costs. Your Legal Profession Act addresses funding. I've got a couple of citations up there. In addition to just plain old money, technology, office space is important. And I will say this a lot during this session now, as well as during the panel. Training, and development is incredibly important, not just for your system staff and for the Bar Council staff, but for your volunteers. So for your EXCO, for your ethics committee member, for your appeals panel, especially when you're starting from scratch, really, at the very beginning. So it's really important to develop a training program and have that implemented and it be mandatory and happen on a regular basis. I'm not moving here. Can we advance to the next slide, please? There we go. Independence. A hallmark of a good lawyer discipline system is going to be its independence, and that can mean a lot of things. And it's important that the system not only be independent, but that it be perceived as such, not just by the bar, but importantly by the public, because the system exists to protect the public. So what independent means is going to depend. It's going to vary from country to country. In the United States and under ABA policy, that means, because state Supreme Courts regulate our profession, that discipline should not be handled by the Bar Association, but rather it should be handled by a separate Supreme Court agency that is professionally staffed. And again, that's because our judiciary regulates the profession. In other countries, like here, that's just not the case. In other countries, you have Parliament, who has the authority to promulgate laws about the regulation of the legal profession. In some countries, you have co-regulation between the legislature and the courts. And a reason for the not having a bar association do that, at least in the United States, is there's a concern that the representational and the regulatory roles of the bar could be perceived as conflicting. So there's, again, because the goal here is to protect the public, and the public's perception is incredibly important. They have to have trust and confidence in the system, as do lawyers. And so you want to make sure in the United States that we have that as separate as possible to help with that perception that the system is independent. In the United Kingdom, for example, it used to be that the Law Society of England and Wales, in addition to representing members of the bar, did the discipline and took in the complaints. There were complaints that was not going well for the public. And so Parliament passed the Legal Services Act in 2007 and created a new overarching regulator. It took that regulatory authority from the Law Society and created the Legal Services Board, which actually is populated by a majority of public members, not lawyers. And that oversight, Legal Services Board, is the regulator of other individual regulators like the Solicitors Regulation Authority, the Bar Services Board that regulates barristers, and the other regulator that regulates the conveyancers. So that is a step that they took in England and Wales to increase the independence of the disciplinary system. Another common hallmark of independence is the separation of investigative and prosecutorial duties from the adjudicative. Because the lack of that type of separation can lead to perceptions, again, of unfairness by the public if you have the same investigator or prosecutor actually adjudicating the case. And so what you typically have in a lot of jurisdictions that separate the investigation and prosecution roles is you have a professional disciplinary counsel who does the investigation and prosecution, and then you have members, volunteers, or professional adjudicators who handle the adjudicative duties. So with the construct, within the construct of your Legal Professions Act, your new system does have some separation. You kind of merge a little bit the investigation and the prosecution piece. And those are typically separated in more mature systems. But you have that separation at the exco level. So you have the investigation stage and the kind of prosecution stage, and then you get a report from your ethics committee members that goes to your exco, and they act as the adjudicators based on the report and recommendation of the ethics panel. You also have a separate appeals committee, so if a lawyer disagrees with the decision of the exco, they can appeal it to your appeals committee, and ultimately, if they desire, to the high court. So another component of independence that is a little bit controversial is to have public members participate in the system. We do that in the United States, they do that in Canada, they do that in some other jurisdictions, and in as many jurisdictions that permit it, there are those jurisdictions that don't. We do that in Illinois, where I was practicing law and prosecuting lawyers. The public members served as adjudicators. We would have a panel of 2 lawyers and 1 public member. And I have to tell you, I found them to be quite helpful. There is the inclination for us as lawyers to think, well, they don't know the law, they don't know evidence, they're not going to understand. I have to tell you, it was amazing to me how frequently we lawyers were so focused on how to ask the question the right way, how to comply with the rules of evidence, and how to follow the procedures that the public members who have been screened to make sure that they're appropriate for the role would just cut to the chase and ask the question, and typically save us a lot of time. And again, because the primary purpose of discipline is to protect the public, when you involve public members in the system, you're giving them some buy-in to the system. And one of the functions of the system is always to do outreach, because you have to educate not only the bar, and that's why we're here today, but you have to educate the public about the system, how to find the system, what the system is there to do. And when you have your, when you're lawyers and you have your colleagues, your people, talking to you about this, you tend to pay more attention. And so when you have your public members able to speak to public groups about the system, it also helps instill confidence in the system. So again, you don't have that here. That is not, inconsistent with what happens in a number of jurisdictions, but something to think about in the future. It's often more difficult in smaller jurisdictions, understandably, especially jurisdictions that are as well connected on social media as you are here in the Maldives. Next slide, please. So accessibility, that's also critical because, again, you're here for the public and you have to be accessible to the people that you're meant to serve. And so these are some components of accessibility of a system. Your Bar Council has taken really good steps to do this, including having information about the system on its website. It's well organized, it's easy to follow, it's easy to understand. Next slide, please. So you also have a complaint form online. So there you go. You have your downloadable complaint form. I can tell you, while most jurisdictions in the U.S. do have a downloadable complaint form, not all of them do. There are other jurisdictions where that's not available. So having this form online is excellent, but accessibility also means things like language accessibility and making sure that the public who may not have access to technology or know how to use technology, isn't sophisticated in its use, can easily access the system and be able to file a complaint. And with regard to that, another part of helping those who want to file a complaint against a lawyer is you have people who can't write. And they may have a valid complaint. And so the system, even if it has rules that require a written complaint, as you do, will have staff from the system help the complainants reduce their grievance to writing so that it can be investigated. And I think this type of assistance seems to me to be totally consistent with your rules of professional conduct, with the spirit of those rules. I think one of your rules talks about lawyers shall take special care in providing services to persons who may be suffering from impediments to their understanding. Next slide, please. It's always the technology. Responsiveness, also critical. Your rules governing disciplinary proceedings include provisions to ensure that the system is responsive. It requires timely response to communications with complainants as well as respondent, and the timely conducting of investigation and the issuance of reports. And there is a relationship between responsiveness and the feeling by lawyers and the public that the system is accessible and accountable. Everything is intertwined. Next slide, please. So fairness. When we talk about fairness, you can see there's a lot at play, a lot going on here. Transparency ties into the accountability of the system, which I'm going to cover in a little bit more detail. And we talked already about separating the investigative and prosecutorial components. Timely caseload processing, I don't wish to get ahead of where our next panel is going to be, but certainly fairness requires timely and efficient caseload processing. Lawyers should not have matters hanging over their heads. Being on the receiving end of a disciplinary complaint is very stressful, and the same is true of complainants. It's a stressful process for them. So fairness dictates that they too are entitled to a prompt resolution of their complaint. More mature systems have specific time standards or time guidelines, and I'm going to talk a little bit more about that, so I'm going to put a little hold on that. The other piece is expunction of dated records. So when you have a lawyer who has been complained against and the complaint has been investigated and dismissed, the question is, should it just remain in the system as a dismissed complaint forever? Many jurisdictions actually, after a period of time, will expunge from the system those complaints that have been dismissed against a lawyer. Even though they're confidential, the lawyers take some comfort in knowing that after a period of years, that is going to be expunged. And the other piece is criteria for reinstatement and readmission. Because the purpose of discipline generally, globally, is not to punish a lawyer. It is to protect the public and protect the integrity of the profession. Lawyers should be given an opportunity to apply for readmission or what we call reinstatement. In some jurisdictions, when a lawyer has had their license revoked or they are disbarred, they have to take the bar exam again. And nobody, that's a big step. Whereas a lawyer who has been suspended for a period of time may have to apply for reinstatement. So if you have a lawyer who has been suspended for a period of years, you want to make sure, one, that they now have the appropriate character and fitness to practice law, but you also want to make sure that they've stayed current during that period of time away. And so they can petition for reinstatement and ask for the regranting of the privilege to practice law of their license upon a showing that they now meet those requirements. The right to counsel for an accused lawyer also relates to fairness and due process, and your rules are consistent with global practice in terms of that as well. The one area that I noticed does not seem to be in your rules is a standard of proof, the standard of proof by which allegations of misconduct have to be proved. That is an important component. We'll also be talking about that a little bit, but it's only fair that lawyers accused of misconduct understand and have that information so they can appropriately prepare their defense. And the same is true for complainants and the public. So something to think about in the future as the system matures is development of that standard of proof. Next slide, please. And of course, every system has to be accountable. It has to be accountable to the public, it has to be accountable to the bar, it has to be accountable to the entity that created it. And this can be accomplished in really a variety of ways. Perhaps the most controversial would be that once the disciplinary investigation is complete, that is a confidential investigation. That is globally typically what happens. But in a number of jurisdictions, once that is complete, and there's a determination that the lawyer should face charges, disciplinary charges, that there's sufficient evidence or probable cause that they have violated the rules of professional conduct, those hearings in many jurisdictions are open to the public. And anybody can come, like any trial, any civil trial or any criminal trial. Again, the investigation stays confidential, but the trial and anything that happens after, including the discipline, is public. This is something that happens in the United States, with the exception of very few jurisdictions that still keep it confidential, in Canada as well as other countries. So, food for thought, again. But as I mentioned, at a minimum, the final order of discipline should be public. And I noticed that your website and your rules would provide for the posting of final discipline against a lawyer on the website. Next slide, please. So I want to talk about a few additional tools to enhance the effectiveness and accountability of the system. One of those is you might have a situation where you have a lawyer who is engaged in conduct, or you have sufficient evidence to show that that conduct is ongoing and presents a serious threat of harm to the public and to the integrity of the profession. And you want to stop that conduct from happening while at the same time undertaking your disciplinary proceedings. And so a lot of jurisdictions have what we call an interim remedy, an interim suspension for threat of harm. And what that allows, it's like a temporary restraining order. And what that allows the disciplinary agency to do is to go, probably in this case, to your exco and say, we have this evidence. The ethics panel goes and says, we have this evidence. This is very serious. There's ongoing harm. We're going to need more time to investigate. But while we're doing that, this lawyer shouldn't be out there because they're dangerous to the public. They're dangerous to the profession. And so you can get that interim remedy that would then place the lawyer on what we call an interim suspension. And then the disciplinary proceedings would continue and final discipline would be imposed. So that is kind of an additional tool that a lot of jurisdictions have. Again, something as your system matures to think about. Let's see. Next slide. Technology, which clearly I'm having a problem with today. So another thing that is important for not only the effectiveness of the system, but for its accountability and transparency is technology. What I have found doing my consulting and talking to regulators around the world is no matter where you are, cases are becoming more complicated. And in order to properly investigate, the disciplinary agency, in this case the Bar Council, has to have the adequate technology with which to do that. So if you have, for example, a lot of cases where you are having mishandling of funds, or there is an increase, for example, in money laundering cases globally, you need the ability to have the technology to allow you to analyze those types of financial records. And that technology is out there. In addition, having a robust website that the public can come to and easily navigate and find information, you have that. You know, I've taken as deep a dive as I can take with the English part, but it's easily broken down. You're posting your consultations, you've got your rules, you've got your regulations, you ultimately have your disciplinary decisions. And so that's an incredibly important piece too. And the other part is, again, it goes back to training. Your system volunteers, your system staff need to understand how to use these technologies, not only to investigate, but it's important that there be an understanding and staying current on technology and how it's used in the practice of law generally, because in the context of your investigations, you're going to have to understand how lawyers are using technology, how clients are using technology, cloud computing providers holding things in the cloud, and all of that's going to be important because it implicates the lawyer's duty of confidentiality. So you have an obligation, an ethical obligation, to hold confidential the information relating to your client unless the client consents or unless a court orders you to do so. Well, with the advent of technology, the risks have changed a little bit. So it's no more about keeping paper records locked in your office. You may not even have an office. Your office may be entirely online. And so you're going to be using Google or Microsoft or some other form of technology in the cloud, an off-site server somewhere that's not in your office or in your home. And you're going to have a third party who may have access to those documents. And so you have to take care to understand how that works in order to protect your client's confidentiality. And as the regulator, you also have to have an understanding of how that works. If you're going to be investigating and prosecuting allegations that a lawyer has violated their duties of confidentiality in a way that implicates their use of technology. So these are important things, and again, this ties into training. The other piece, if we can go to the next slide, please, is what I mentioned before, these kind of another form of interim remedies, alternatives to discipline or diversion. That way where you get a complaint against a lawyer, and I would say globally, 90% of complaints against lawyers have to do with lack of communication with their clients, billing issues, or minor instances of neglect. Some things that are law practice management based. You missed a court date because you didn't put it in your calendar, or you don't use a calendar. And so these alternatives to discipline programs come in very handy when you get a complaint against a lawyer of this nature, lawyer's not a bad person. They haven't engaged in serious misconduct. It's not something you would really discipline them for, probably more seriously than a reprimand. And they're educable, and you think this can be remediated. And so what you would do you would talk to the lawyer and say, look, you did breach the rule in a very minor way. We'd like you to engage with us and enter into an agreement where you go take some remedial measures, whether it be courses, CPD courses, or some other form. Perhaps they need somebody to help them with their law practice management skills, so maybe assigning a member mentor to them. And you enter into that agreement, and if they successfully fulfill the terms of that agreement, then the complaint is dismissed. And so the lawyer is helped. It's ultimately going to be good for the clients, and the system itself doesn't have to expend all those extra resources that it can be devoting to serious misconduct that jeopardizes the public. And so that's, we have one more slide, I think. If we can get to the last one. Excellent. So the sanction standards. As I mentioned, that's the framework to help your adjudicators ensure that they're being consistent in their discipline. It's basically a framework. I don't know if you have sentencing standards here in your criminal cases. It's akin to that. It's not completely analogous, but it's akin to that. And so we'll talk a little bit more about how that impacts on efficiency. But consistency in sanctions is certainly something that instills confidence in the profession, that lawyers who do the same type of misconduct are not going to be treated differently by the system. So that also shows that the system is fair. So that's generally my overview of where you fit in the global scheme of things. I think it's fair to say, based on what I've seen in my experience, and I was here in 2019 when you were just starting, is your bar council has really achieved an incredible amount in a short period of time. I mean, the bar exam in and of itself is a huge accomplishment. But to launch an ethics system and to launch a disciplinary system, and I understand, to start from something that you didn't have before is a big cultural change. It's scary, and I get that. And so I want to make sure that if you have any questions for me before we move on to the next presentation, that we have some time for Q&A. So anybody have any questions? Come on, you've just had lunch, you're energized. Huh? I might ask you questions. Yes?
Investigation sort of kick off. I don't know if you heard the first part of that question, whether it was projected.
Tipping off.
Of an investigation. So something comes to mind. So in England and Wales, when the SRA launches certain investigations, you have interventions team that goes in and does like dawn raids in the mornings. And I wonder whether in a small place like Maldives, or particularly in Mali, you might have someone find out that they're being investigated, and then that could quickly lead to destruction of evidence and so on and so forth. So
yes, and it typically happens in, I know England has a no tipping off rule, typically in the anti-money laundering context. So there are these tipping off rules that exist in other jurisdictions. In the money laundering context, in that kind of criminal context with a criminal investigation with a solicitor or a lawyer. But generally speaking, in disciplinary proceedings, in most cases, you're going to get the complaint, you're going to review it, and you're going to want to send it on to that respondent to get a response. So depending on the nature of it, some of it's not going to be avoidable. You live in a very close jurisdiction, but the nature of the confidentiality rule certainly means nobody from within the system can say anything. There have been concerns about the confidentiality by the complainant, if you will. So in our system, for example, in the United States, we can't gag the complainant. Confidentiality would apply to me as the investigator prosecutor, but not to the complainant. So it's a risk, I think, but in most systems, you usually have, you don't have raids. I know that is a little unusual in the UK. But most of it is an exchange of information with the complainant and the respondent. And so unless there's a reason not to tip off the respondent, and when I was prosecuting, most of the time that dealt with where you had a simultaneous criminal investigation, we would, in those situations, hold the matter in abeyance so as not to interfere. I don't know that that really answered your question, but the UK is unusual in that way.
Okay. Yeah. I mean, thank you. I think it touches upon what I was trying to, yeah.
Whoa. Other questions? So let me ask you a question. How many of you are admitted in more than one jurisdiction? So you're admitted in the Maldives and you're admitted to practice elsewhere. I'm guessing maybe you are also admitted in England and Wales. Anybody else admitted outside the Maldives? Okay. Okay. Any other questions? No. All right, well, I will look forward to seeing you at the next panel, and I think we have a couple of additional presentations before we get to that. So I will see you shortly.